Okay, well, just to introduce this topic, I'll be talking about the sanctions, focusing on the price of Russian oil. Okay, so as you all know, since February, really since 2014, but even more so since February 2022, there have been a variety of sanctions imposed on Russia in response to its invasion of Ukraine. Many of these have maritime components to them, so including the blacklisting of persons, including ship owners, including shipping companies, including vessels. In addition to that, we had seen other types of maritime.
Y luego lo vuelvo a probar. Si no, cojo el tuyo.
Just a second. Akim, Akim, can you mute yourself, please?
I'm sorry. I'm muting. I'm sorry.
Thank you.
So there's been other types of maritime sanctions as well, including restrictions on where Russia-connected vessels can go, okay, and also in particular sweeping bans on the import of Russian oil into certain countries, including the United States. So what has happened more recently, so in the last 10 months or so, is that a group of allies have gotten together and crafted a new, I need to open,
Just a second.
I need to make it bigger so it's
Yeah, I'm sorry.
Okay. So what's happened more recently is that there has been efforts to try to impact the price of Russian oil going to third countries. Okay, so that's really the focus of this paper. To give you an outline, I want to talk a little bit about the policy rationale driving that approach. I will talk about the scope of those rules, including the scope of the cargo that applies and the voyages that apply. I'll talk then about the regulatory guidance that has been provided by the various sanctioning authorities, the coalition nations. And then really the heart of this presentation is looking at the contractual tools that have emerged in response to those compliance obligations. Okay, so to start, just to give you a little bit more context, so once again, there were already many sanctions in place, put in place by individual nations acting unilaterally and then sometimes also in concert to react to Russia's aggression. But in terms of the price cap in particular, there was coordinated action between the G7 nations. Okay, so you can recognize the flags there, Canada, France, Germany, Italy, Japan, the UK, the US, the G7 major industrialized economies. In addition to that, there was participation at the EU level and some other partner nations outside of the G7 and outside of the EU, including Australia and Norway. But the idea behind this price cap is to try to figure out a way to limit Russia's ability to generate revenue through its sale of crude oil and other petroleum products, while at the same time trying to stabilize the supply of energy around the world. So it's kind of a lofty aim, and it involves balancing these two goals. But in the end, the solution that these coalition nations came up with is that they were going to try to weaponize services provided for maritime transport in the transport of Russian crude and other petroleum products, to try to take advantage of the fact that there are many first-in-class, top-class, well-regarded maritime services in these nations. And so therefore, there was an opportunity to limit the price of Russian oil, even going to third countries that are not participating in the sanctions, by regulating what these various service providers can do in terms of pricing of the underlying trades. Now, this becomes a little bit complicated in effectuating this goal, but that is the general idea. So I think a good example of this is P&I insurance, as we can look at these nations that are involved. All the P&I clubs are linked to these countries in one way or another, right? So with the UK, of course, the US, the EU, and Norway, of course, where GARD is located, we have all the P&I clubs being subject to these rules. Okay, so what I'd like to do now is turn to the price cap itself and talk a little bit about its scope regarding cargo. This is a synopsis taken from regulatory guidance from all these different nations and from the EU as well. So it's kind of bits and pieces of the regulatory guidance from the US side, from the UK, from the EU, etc. And so I've tried to summarize things rather than to try to point out any particular differences between those regimes, because they are pretty harmonized. That's the reality. And so here is the way that it works. The cargo that is subject to the price cap must be of Russian origin. So it's going to be departing from a Russian port, but it must be of Russian origin. So if it's, for example, piped in from some other country and therefore would have a different country of origin, it would not be subject to the price cap. Okay, so that is the first step, is making sure it's of Russian origin. If it is crude oil, the cap, as it stands today, is $60 per barrel. Okay, there are other petroleum products that are also subject to a price cap, but they're different price caps, because there's a recognition that some products trade above the price of crude. That's what are being called premium to crude petroleum products. So think, for example, refined products like gasoline or diesel. We also have products that are cheaper than crude, so discount the crude. So, for example, high sulfur fuel oil and what is called waste oil is also something that would be considered within this category. And so there are different caps applied to those two different possibilities: $100 per barrel for the premium to crude, and then $45 per barrel at the discount to crude. Now, how do we know what the cargo really is? Well, when cargo is sold and ultimately needs to cross borders, there would need to be customs paperwork filed, which includes categorizing the cargo under the tariff schedule, as we call it in the United States, or the HS code, as it's called in a lot of the rest of the world. I believe in the EU you call it the CN code, the Common Nomenclature Code. But this is really just a way to identify what is the cargo. Okay, so we have specific designations for crude, and then there's also one for other petroleum oils. So those are the two identifiers that we would be looking at to know whether or not the price cap applies. Okay. There's a couple of rules to be aware of, and one is that commingling the cargo with non-qualifying cargo does not prevent the price cap from applying. So imagine a tanker shows up at a Russian port and it's 60% full of Saudi crude. If you just fill the rest of the tanker up with Russian crude, that does not allow you to just avoid the application altogether. So there's two ways of looking at it. One is the price cap would still apply to the Russian crude that's added. Another way of looking at it is the whole vessel might be subject to the price cap, depending on whether it's documented or not, how much of it is Russian. Okay, and so that's one rule to be aware of. Another rule is that it's not possible to circumvent the price cap by entering into some kind of profit-sharing agreement with the Russian exporter. So, for example, to get around the price cap, somebody might come up with a scheme where the petroleum product is sold at or below the price cap, but then they promise the exporter, once we sell it, once it's outside the scope of the price cap, we'll give you some profits. That is not allowed under regulatory guidance. So those are the basic rules in terms of the scope of the cargo application. But what about the voyages? Well, critically, this only applies to maritime transport. Pipelines don't count currently. So pipeline sale, the sale of Russian petroleum products going through pipeline only is not subject to the price cap at all. Now, it might be subject to other sanctions, depending on what the rules of the nation are, the destination nation. But if it's maritime transport, it would apply, the price cap would apply from the time that the cargo is loaded onto the tanker until the time that it clears customs in the third country. So the third country being the nation that is not Russia, and it is not a sanctioning authority. It's not a coalition nation. So imagine China, India, Turkey, those nations that are not participating in the price cap, but might be interested in purchasing Russian petroleum products. The rule is that moving the cargo to those destinations would be subject to the price cap for all the maritime services that are provided for that transaction, including the insurance and everything else. Okay, but we'll get to that. It also applies, the cap also applies to subsequent sales of the cargo during transport. So as we know, this happens with commodities like petroleum products. It can be sold sometimes many times during transport. The price cap applies to those subsequent sales. It's not just the first sale. It's all sales that happen during that transport from the Russian port to the third party country. Okay. When does it cease to apply? It ceases to apply after customs clearance in the third country, as long as it's consumed within that third country and or it is transformed into non-qualifying cargo. So for example, if the cargo is moved from Russia to Turkey, it is refined there in Turkey and transformed into something else. Maybe it starts as crude and then it becomes gasoline. It is no longer subject to price cap because it is no longer of Russian origin. It would actually shift to being Turkish origin for purposes of classification with the tariff schedule, for example. And so that kind of transformation of the cargo would cause it to cease to apply. Now, if it goes into a third-party country, clears customs, but it is not transformed and not consumed in that nation, and instead it's just transshipped out to somewhere else. So in other words, it goes through clearance, but then it just stays there, and then it gets shipped to another country. The price cap will kick in once again. It will still be qualifying cargo, and it would still be considered a qualifying voyage. So those are the rules as they stand. It's a little bit more complicated than that, but I'm trying to keep it relatively simple. So those are the qualifying voyages. What about the exceptions? A couple of interesting ones. One is Japan. So Japan as a G7 nation was very much involved in the development of these rules, but Japan has requested and been granted an exemption for certain types of products that come from a special project right off Japan's coast, the Sakhalin II project, which was, my understanding, Japan was involved in the financing of that project and very much depends on the energy products coming out of that project for energy security. So for that reason, although they have agreed to impose this price cap, Japan has requested and been granted authorization. So if you look at US law, you look at UK law, you look at EU law, Japan is allowed to do this, at least temporarily, at least for the time being. If I'm not mistaken, I believe there is a designated date in which that will expire and they would need to seek a new exemption. But another one to be aware of is Croatia. Croatia has also requested and been granted an exemption for a specific type of product called vacuum gas oil, VGO. Okay? And Croatia has asked for an exemption and been granted the exemption because it says that it is necessary in order to engage in refining at a particular plant in Rijeka. Okay, so up the coast. So apparently this VGO product is kind of difficult to get on the market. There's not a steady supply of it. And for that reason, there's been a request for an exemption. And there is one under EU law, under US law, under UK law. and presumably under the other nations as well, under their laws. There's a couple of others under EU law that have requested exemptions, including some of the landlocked EU countries, but similar framework is in place there. But one other one that I'd like to draw your attention to, because I'd like some feedback on this one in particular, the implications of it, and that is that there is an exemption related to vessel emergencies. Okay, so if we look at the details of that exemption, it specifically allows the provision of services regarding the health and safety of the crew and environmental protection. Okay, so for example, if there is insurance cover for a trade that ultimately is non-compliant, and then there's some kind of emergency event, like a vessel runs aground and threatens to cause major environmental problems, in theory, it is authorized for the insurer to provide cover there, okay, even though the sale may not be compliant with the price cap. Okay. So we'll come back to that a little bit later, but I need to now turn to the tricky part, which is the compliance obligation. So you've probably been thinking all along, how do you enforce this? It seems like an impossible thing to enforce, and maybe it is. Maybe it is. But I'll tell you what the obligations are, and we can talk about whether it works a little bit later on. So the way that these nations, these coalition nations, have sought to enforce or demand compliance with these rules is by placing certain obligations on the various actors that would be considered maritime service providers in the commercial chain. But in what I think is a relatively sophisticated move, regulatory authorities have recognized that the compliance obligation needs to be varied depending on the commercial actor's proximity to the underlying pricing information. In other words, not everybody's going to know what the price of the cargo is. And so for some service providers, there will be a higher compliance obligation than others, or at least a more specific obligation than others. Okay? So the way that guidance has been offered, once again, this is harmonized, remarkably, US law, UK law, EU law, etc., is that there's a recognition that maritime service providers in this context should be categorized into tiers. Tier 1, Tier 2, Tier 3. The Tier 1 actors are the actors that are most likely to have access to pricing information. The sellers, the buyers, the brokers. So where might they have access to that information? Commercial invoices, contracts, maybe other types of documents that would say for sure whether the cargo at issue is in compliance with the price cap. So the obligation imposed on those Tier 1 actors that do have access or should have access to pricing information, their obligation is to retain and to share that information with other parties in the commercial chain. Okay, so those importers, for example, need to keep those commercial invoices and be willing to pass them on, or at least promise that their trade is in compliance with the price cap. And that is what we are calling attestations. They must give attestations of compliance to others in the commercial chain. What about those actors that are one step removed from the pricing information? We are calling those Tier 2 actors. Those Tier 2 actors are intermediaries such as the ones that help facilitate trade finance, or vessel charterers. Vessel charters that are entering into agreements with cargo owners to move petroleum products. Those are considered Tier 2 actors. Now, what must they do? They must request the pricing information or attestation from the Tier 1 actors, and then be willing to share that with others in the commercial chain. Okay? So vessel charters in particular, we'll come back to that because we'll talk about charter party clauses that have emerged to deal with this challenge. Then we have the Tier 3 actors. These are the ones that are even further removed from pricing information. And there are many of those that might be involved in maritime transport services. So think, for example, the ship owner, Think, for example, the P&I insurer, the hull insurer, the cargo insurer, maybe the reinsurer, okay? So there are many actors that might be considered in this other tier, this third tier. They're quite far away from the underlying pricing information. They don't know much about the underlying sale, but they still have an obligation. Their obligation is to request attestation from their counterparties, which are probably going to be tier 2 actors. So for example, the ship owner would need to request that from the charterer. Or it might be requesting that attestation from other tier 3 actors. For example, the ship owner might need to be, the insurer might need to request attestation from the charterer and then give attestation to the insurers. Okay? So that is currently the framework. Now, the way that this is being talked about in the various regulatory circles is a little bit different depending on which jurisdiction. In the U.S., the terminology that's being used is safe harbor. If the commercial actors comply in this way, they will be given safe harbor. They will be at least protected from strict liability for sanctions violation. Okay. The UK guidance does not use that language, but they indicate a similar framework that they're not going to necessarily go after actors that act in good faith to comply. The EU guidance is similar to that effect. And so these rules appear to be, once again, uniform through the coalition jurisdictions. This chart, I think, is pretty helpful. This is from the UK guidance. So we can kind of break it down here. These are the tiers that I've already talked through, but sometimes it helps to see it. In the tier 1 lane, we have the buyers, the sellers, the brokers. In the tier 2 lane, the ones that have to request documentation and or attestation from the tier 1 actors are the folks like the charters. And then in tier 3, these are the ones that are probably going to need to share attestations with one another. Okay, so the P&I insurer, for example, might demand attestation from the ship owner. The ship owner might be demanding attestation from the charter, and you can see how this is supposed to work in practice. Okay, so we'll move on from that. What is the practical impact? Well, as we can see, there is a pretty serious compliance burden. Everybody wants to receive safe harbor. They don't want to be penalized with sanctions. They don't want to be blacklisted, right? And so there have been efforts, especially with the insurers, to react to this immediately. Okay, so even before these rules came into effect, the international group of P&I clubs started circulating, the various members of the international group of P&I clubs began circulating guidance on how to do this, how to actually handle this attestation and these compliance obligations. Subsequently, BIMCO published a clause dealing with the relationship between the ship owner and the charter, dealing with the very same question. And so these are the contractual solutions that we have on the table. So I want to talk through these, and then hopefully we can see how this would play out in the real world. The P&I attestation document that was circulated in December 2022 by various members of the international group of P&I clubs is a relatively short document. So it is a form that contains just a few substantive paragraphs. But before we look at the attestation itself, there's something else that's mentioned in the guidance that was circulated, and that is there's a recognition among the P&I clubs that in most scenarios, both the ship owner and the P&I club are going to be considered tier 3 actors under the regulatory guidance. So their obligation then is to share attestations with one another, and so this is a response to that obligation. So what does the attestation say? Now I have the language here, but what I'll do is try to break down the main components of each paragraph. So there are just 4 really substantive paragraphs. The first one, it's a broad warranty of compliance. Here, the assured must warrant that they are in compliance with the price cap. It's as simple as that. They're saying, we promise that we are in compliance with the price cap. That is the heart of an attestation, right? So that's a relatively simple concept. But there's another representation buried in there in the last sentence, and that is a warranty and a promise that there is no evading, circumventing, or attempting to violate the price cap. So it's really, it contains an additional promise there that's slightly different than the first promise. Okay. So that's what we see under paragraph 1. If we look to the second paragraph, we can see that there is an information sharing agreement where the assured is promising to give information to the club, such as the information it's received from other actors, including those that are in the other tiers. So for example, if the ship owner has received information from the charter and the P&I club requests it, then they have an obligation to share that. That's the promise in paragraph 2. Okay? So that's upon request is what it says there. And if I'm not mistaken, 5 business days. They have 5 business days to do this. Okay? In the next paragraph, we can see that there is an obligation to notify, if there's any funny business going on, if there is any indication that the trade that is happening at the moment is not in compliance. There's an obligation to notify the club, and the club is retaining the authority to tell the authorities about it, to tell the regulatory authorities about it. So they're retaining that power. Of course, they have the power anyway, but it's being specified here in the agreement that there's, just to make sure there's no doubt about that. Okay, and then we have in that last number 4, last substantive paragraph there, we have what is essentially a sanctions exposure clause. Not unlike the ones that we have seen circulate in recent years, where the club is saying, we're not going to pay if we might be exposed to sanctions. And if we think that there has been a violation of sanctions, we will immediately terminate cover. Now, that is no longer controversial. Maybe 10 years ago that was controversial, but their sanctions clauses are so highly circulated today, especially in P&I club rules, that this is basically standard. Okay? The difference is it is now in the context of the price cap, and it is in the context of this attestation. So this would add to the sanctions clauses that already exist under the P&I club rules. Okay. All right. What about charter parties? So BIMCO released its price cap clause a little bit later. So in the summer, if I'm not mistaken, it was June of 2023. What you'll see here in this clause is some language that mirrors what we have seen in the P&I attestation. The difference, though, is that we're not just talking about Tier 3 actors, because the charter, as you recall, is a Tier 2 actor. And it might even be a Tier 1 actor if it owns the cargo, or if it is purchasing the cargo, right? Put it that way. Okay, so the compliance burden is higher, I would say, under this clause, because it's higher under regulatory guidance. What do we see in this language? In the first paragraph there, we can see once again a broad warranty of compliance. The charter is promising we are in compliance for this, for all trades under the charter party. So if it's a voyage charter, then that particular voyage is in compliance. If it's a time charter, then there's at least a broad warranty of compliance there that all the trades are going to be in compliance. Okay, but what we see in paragraph 2 is even more specific. In fact, BIMCO is calling this a specific warranty in paragraph 2, where there is an obligation for the charter to issue an additional promise every time cargo is loaded on the vessel under the charter party. So if it is a time charter, every time that the vessel loads petroleum products, then it's going to have to give an attestation, not just in reference to this clause, but through a document that is attached to the clause as an annex. So I'm going to turn to the annex before I look at the other substantive clauses because I think it's easier to understand that way. Here's the annex. This must be issued by the charter every time cargo is loaded on the vessel under the charter party. As you'll see, the language is actually quite similar to the P&I attestation. Okay, at least in the sense that it's a promise of compliance. What we also see here is language that has been drawn from the regulatory guidance. So there's some sample language that has been included in US OFAC guidance, in UK H and Treasury guidance, in EU guidance, using this language or something very similar. Okay, and so what does it say exactly? It says that the charters confirm that the cargo loaded is in compliance, and it says they warrant and attest that, and there's three options, three possibilities. The first option is they have price documents. They have documents that demonstrate that the trade is in compliance. Or, it says or, right? Or they have an attestation of price compliance. So a promise of compliance, if not the pricing information. Or the third option, there's a license, right? So if the cargo is going to that refinery in Croatia that has a license, then it would be subject to that rule, and therefore that would be enough for the charter for the purpose of signing this annex. So that is what is required, at least the substantive language. You can see they have to retain it for 5 years, etc. But that is really the heart of the document there. There are a couple more substantive provisions in the charter party clause that I want to draw your attention to, but very much they mirror what we saw in the IG attestation document. The first is an information sharing agreement. The charter, like we saw in the P&I context, the charter is agreeing to provide additional information at the request of the owners, but they only have 3 days, not 5, 3 days. Okay? So that's one difference. We also see that under the next provision there is a mutual obligation to notify. So this is both. This is going to apply to both. So we have seen so far, it seems like a very owner-friendly charter burdensome clause. Well, at least there's one provision here that applies to both, and that is that both the owners and the charters have to be willing to exchange information if they believe that the vessel might have been involved in a non-compliant trade. Okay. And then probably one that you would already be expecting, consequences for a breach. Consequences for a breach, right? If there's a violation of the clause, the charter party can be canceled, right? That's not unexpected, really. There's an obligation too for the charters to indemnify the owners for any losses, including, we would think, sanctions enforcement penalties that are applied. But then in addition, you see there on the last paragraph, the subparagraph 3 there, that there's an obligation for the charters to respond to regulatory authorities if they demand that the cargo be offloaded. They have to be willing to give orders to allow that to take place. So there is a lot going on here, right? As you can see, the final language there, the clause has to be incorporated into subcharters, into bills of lading and other documents under the charter part. Okay? So those are the contractual experiments underway. So what is happening at the moment? Well, what's happening at the moment is that the price of Russian oil is trading above the price cap. It is above the price cap. So that would suggest that there are some non-compliant trades out there, or that the maritime service providers in the coalition nations are somehow avoiding these trades altogether. But that's where we are. So this is a relatively new happening there, where the price cap has been exceeded. It was somewhere around July when that happened. Okay, except for the commodities flowing out of the Pacific side, and that's probably because of the exemption that Japan has. Okay, I don't know that for sure, but that's my thought on that. Okay, so rather than really giving an argument or like making predictions or recommendations, I just want to give a couple of other comments to see if we can get a discussion going on this issue in particular. Not sure where my notes are on that, but I'm going to try to go off the top of my head. As we heard already today, Lloyd's List has been reporting that there are something like 500 tankers that are in the dark fleet, right? They are old tankers that deactivate their AIS and try to hide their activities. Okay, so that's happening. There are trades that are happening that are above the price cap. That's another fact to be aware of. Okay, and there's also been reporting that a lot of Western insurers are not providing cover for these types of trades at all, that they've just pulled out of the business altogether. So my question for you to get this discussion going is, what does that mean? What are the implications for that, those developments? And does that mean, I think I'm particularly interested in what you might think about whether there is a risk of not being able to pay claims for oil pollution coming from these tankers. So we talked about today already where there might be a gap that could exist if we're talking about non-IG P&I clubs saying they're providing cover, and then we might have a gap in the sense that if there is some kind of damage caused by a mine or some kind of other act that's subject to the war exclusion. So that's the end of the presentation, but I'm really interested to hear what you have to say.
Susanna, let's see.
Be the one.
Yeah, I should be.
I'm reading news from Reuters. Russia has managed to keep its global oil export at close at the level seen before Moscow's invasion of Ukraine. But its share of the European market and revenue plunged due to Western sanctions. This is according to the International Energy Agency.
I think also, I was just thinking in terms of illegality of contracts as a basic concept of law. You try to go back to that and see, what device the regulators of some countries, obviously we're not talking of global, we have to remember that these are not global regulations. These are regulations of a handful of countries that have a policy, their own policy rationale. But in legal contracts, if I recall, somehow when illegality or something immoral is perceived by the law, that tarnishes the whole transaction. What I'm having difficulty with is that on the one hand, the regulators believe that it's somehow, there's that tarnish, there's that stain, but they are still sanctioning the transaction up to a level, which does show in a way how these countries and regulators are still wanting to get some benefit, get a benefit out of it. So I think the judge would find it quite challenging with respect to these, or with reference to these traditional concepts of illegality, right? Because legality will ab initio initiate the contract, but we don't have that. Similar to the U.S. sanctions, always the same models. The U.S. has the tendency to sanction people outright, like they're preventing from doing any business or companies. But in this case, it's like, no, we are allowing the transactions to happen, but up to a certain price. I don't know if there are precedents to that. That could also be another question too.
it's like creating a chilling effect that would at least limit the revenue that can be generated. Which is, I mean, honestly, that's the articulated goal of the coalition. To do that. So maybe it's achieving that goal. I don't know. In that it's still allowing trades to the point that it's creating an environment where there's still a stable supply of these critical commodities, but generating less revenue and maybe giving opportunity for other markets to sell similar products.
It's a sort of control of market price.
Yeah. Indirectly. So.
But it is so, if I can just notice, it seems actually that it is quite complicated and demanding to comply with these requirements, and which maybe might lead many of the insurers, and you mentioned that the Western world is more or less entirely backed up from these sort of trades and transactions. Maybe it's just too complicated to, on a daily basis, comply with these paperwork requirements, and then they just say, no, we just are not going to do any business. And in fact, at least one of our Croatian insurers, which is amongst the leading ones as regards cargo insurance, they have an internal policy saying absolutely no Russian origin cargo can be insured in any way. So they're not even going to see whether there are exceptions, whether there are ways of complying with. They just said, no, we're just not going to do it because it's too complicated to set up the whole procedure internally, to have enough people to, study every transaction and say this is the way how it should be.
Right.
I understand. I know what you're saying, but I think if all insurers in the world get the same approach, there will be no oil Russian at all for any price. They would all just withdraw from the Russian market. Maybe that would be best for the peace in the world, but I don't think.
No, it's not possible. I mean, that's
And
why
also-
the G7 are only so many, and they said, okay, we'll use our stakeholders of our markets to try and impose and implement this sort of policy. And we are aware that there is the rest of the world who don't have to follow the same policy, obviously. So I think that would be just a very theoretical goal to exclude
No,
entirely.
it is awfully complicated, especially for shipping people or charters, whoever, you get a PhD degree.
To understand what's
I meant to ask you, Richard, what's the view of the banks who finance those ships? They normally take collaterals, like apart from mortgages on the vessels, but they also take assignment of the charter parties. They take assignment of all ships' earnings from those charter parties. There are various obligations on the ship owner to notify about any changes in the up to a certain threshold or above a certain threshold, to notify the banks. Do they have any special view on all this?
It's interesting. The guidance that I've seen, I've definitely looked at the US, UK, and EU guidance, and they seem to be very careful about banks because they don't want to create a scenario where the banks feel like that they can't facilitate these transactions. So again, kind of getting to the point, it's like it seems to be that regulators kind of want there still to be the ability to make these trades. And so they're kind of like placing the bank slightly outside the scope, because it's not the case with the Iran sanctions, for example.
Yeah.
Banks cannot facilitate those at all, right? But if you look at the price cap guidance, it's like there's very soft language about financial institutions. So if you go back, for example, the the tier two, you would think, oh, banks have got to be right there along with the charters. They're close enough proximity to the pricing information that all the guidance is saying, well, it doesn't count for banks that are facilitating the transactions, like your letters of credit, et cetera, they're not subject to these rules. I mean, that's a paraphrase, and I could be getting that completely wrong, but that is my sense.
Yeah.
That is my sense.
Probably, yes, because they want to have as long as possible happy marriage with the bank, without much disruption or problems or questions and things, until a disaster happens, and then that's a domino effect, you know.
From your previous research, have you found any similar kind of measure before this one?
No, no. I mean, especially with the guidance.
Yeah.
Especially with the guidance, I think this concept of recognizing the proximity to the pricing information, I think that's a very sophisticated view of the shipping industry that we have not seen in previous guidance. For example, I don't know how well everybody follows sanctions, but there was a guidance published by the U.S. OFAC in 2020 that required P&I clubs and other insurers to monitor the AIS transmissions of all the member vessels. And that was never the requirement before. And maybe some of you can speak to this. Do insurers have people that can do that just as their job, just sit around and monitor vessel locations?
Lloyd's maybe yes, but I think.
But the P&I club?
I don't know. Probably I would say they might have, but any other insurer which is lower class.
Okay.
Impossible.
Yeah.
But they probably have service, like outsourced services.
Okay, so they can subcontract to like these new
yeah.
companies that are on the scene to help
That I
facilitate.
imagine, yes.
Help facilitate compliance. That's a burden as well, and it's a new burden. It's a new burden, right? But I guess the point that I was trying to make there is that was a controversial guidance because it seemed like the regulators didn't quite understand the industry, where this seems to be more nuanced, more sophisticated, with a better understanding of the complexities of the various actors in the commercial chain.
Maybe it's heard, but in your presentation, are there any sanctions against the ship owners who break the sanctions?
For the price cap?
Yes.
Not yet, that I've heard. But a lot of those are probably settled, and then it takes, I know OFAC will publish when there is a settlement. They'll publish kind of like as a warning.
Right.
Yeah, they'll publish it as a warning, like,
warrant commitment.
the so-and-so insurer has been fined $10 million. And it'll give like a couple paragraphs describing the violations. So I haven't seen that with the price cap yet, but this is very new.
Yeah.
It's very new, and I mean, it was actually trading under the price cap anyway until July, so there weren't any violations, presumably, or there weren't many. Yeah, I mean, I don't know, so these are the spot market rates. I don't know if anybody can explain how that number is developed. I cannot. I cannot explain that, but
dummies work.
So there are plenty of examples where ship owners and others have been hit with sanctions for violating the sanctions on Iran, or the sanctions on Venezuela, the sanctions on North Korea. Plenty of examples of that, but not yet for the price cap.
But as for your comment, and we discussed it yesterday with around the table, in case that there is no insurance cover for a tanker because of the compliance with this kind, would the fund then
Right.
in that case,
Right.
step in.
Right.
And I believe it would, unless it's a war exclusion
Okay.
that we discussed
Yeah.
earlier today.
So if there is if the vessel runs aground,
Yeah, just for a marine peril, which is
marine
not,
peril.
yeah, and it's excluded from P&I because it's violating the guidance, the price of guidance, then P&I could say, you're not covered, although if it's under a CLC, I don't think they can withdraw from coverage either. I don't think they can.
you think that
If it's a CLC regime, I think that they cannot rely on a contractual exclusion, which is not already allowed under the convention. Arif, maybe you can help.
Yeah, you're probably right.
So if you have a CLC certificate, insurance certificate saying that there is a P&I cover in place for this tanker, and the P&I insurer only later finds out that the ship owner is violating this guidance, and the P&I may cancel the cover to the ship owner. But if there is an accident and a pollution, I don't think it's so directly that P&I Club could rely on that defense. I think that
even
they
though
would
regulatory guidance is telling them they should have a Sanctions
because it's not
clause.
overriding the CLC convention. I think that they would have to pay.
But P&I
That's
Club
just
has to-
something to think about. I think because CLC convention only gives one or two possibilities to defend against a claim which is posed directly towards insurers.
Okay.
And this is not one of them, so.
I'm not so, I don't know by heart, but perhaps Adriana, you know better than me, that sort of wording in terms of the defenses of the
Yeah, we can find.
insurer under both conventions. But what also happened in the wake of the crisis in Ukraine was that discussion, I'm sure you all know, in IMO, of the certificates of insurance that could be provided under those conventions. At the time, it wasn't, I think the discussion I followed wasn't about the price cap, it was more about the sanctioned Russian vessels or ship owners, right, and charters. And it was clear that there wasn't really a legal basis to do something, to sort of preempt the issuance of certificates under the conventions. It had to be done under the laws of those countries that were imposing the sanctions. So it didn't bind other countries, other state parties to the conventions. Because otherwise it would be, you're rewriting the convention.
Yeah.
And that is making it even more sort of obviously complicated now, because you have to determine where the ship is, or where the countries lie in this puzzle of, it's a political puzzle, really. But then added to that, the legal implications may vary. And we discussed earlier during the coffee break that I'm not surprised that there's now a push for the emergence of new P&I clubs, not just in the, I mean, I haven't followed them on that.
Kind of like there's a push for trading in non-US dollars transactions, because that's a way to get around the sanctions. So so maybe this is a way for new P&I clubs to emerge. It's like there's new opportunities for other currencies to take the place of the US dollar for international transactions.
Although they would probably not be accepted in most of the ports that are, belonging to this circle of countries that are supporting the.
And those are some of the biggest markets,
they-
because the G7 is.
So,
there's a
yeah,
reason
so
why
they
it's
would
the
be
G7.
somehow kept out, but But I'm sure that there is now more room for these shady insurers and shady traders to actually do illegal trades or just find,
Right.
new markets outside.
Or maybe China, India, Turkey, etc., or maybe the big
Or
ones that
maybe
support
the-
those.
Or those, obviously. But then I think they're all somehow related at some point, right? But this is really interesting.
Yeah, thank you for the
Thank
comments.
you.
It's great. This is great.
Thank you.
So, yeah, I don't think we have a moderator, so,
By the way, this is some information because my colleague should mention couldn't make here. But we talked about this a few weeks ago. It's also a good idea to present research on this topic. So maybe you could talk with her and she can share some ideas.
yeah, of course, of course. Always.
Thank you, Richard. Thank you very much.